This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a conviction about insurance fraud by a plea is still found to be manifestly just, and why a criminal defendant is unable to withdraw his guilty plea, and a fraudster's attempt to withdraw his pleas of guilt stand unless they are found by a court to be manifestly unjust. Defendant Carlo Amato appealed from a March 24, 2022 order denying his motion to withdraw his guilty plea. In State of New Jersey v. Carlo Amato, the Superior Court of New Jersey Appellate Division on October 10, 2023, dealt with the intent of Amato to withdraw Amato's guilty plea. In October of 2017, Amato was indicted by a grand jury for 4 counts of second-degree healthcare claim fraud, 2 counts of third-degree theft by deception, third-degree possession of a controlled dangerous substance, 5 counts of second-degree theft by deception, second-degree insurance fraud, and 2 counts of first-degree financial facilitation of criminal activity. 2 months later, Amato was charged with second-degree financial facilitation of criminal activity, second-degree theft by deception, and fourth-degree making a false written statement. The additional charges stemmed from defendant allegedly filing false disability claims while already under arrest for other crimes. Following issuance of an arrest warrant and execution of a search warrant at defendant's residence in December of 2017, he was charged with all kinds of criminal activity, including possession of a fictitious driver's license, prompting the state to move for his pretrial detention. After the state multiplied the charges against Amato for multiple crimes, knowing he was guilty and had no chance of a defense verdict, in April of 2018, Amato accepted a plea offer from the state to plead guilty only to 1 count of first-degree financial facilitation of criminal activity and 1 count of second-degree theft by deception under accusation, a small part of the charges in the indictments. Before he entered his guilty plea, the state outlined the terms of the plea offer on the record, stating that in exchange for the defendant's guilty plea, it would dismiss all the other pending charges, allow the defendant to exculpate his wife, recommend a 10-year prison term with a 5-year parole disqualifier on the first-degree offense, to run consecutive to the flat 5-year term on the second-degree theft charge, recommended that defendant's aggregate sentence run concurrent to a sentence due to be imposed on his pending federal charges, and consent to delay defendant's sentencing on state charges until after the sentencing on his federal charges. Amato had second thoughts, and in April of 2020, he moved to withdraw his guilty pleas to the 2 state charges, contending his reasonable sentence credit. Defendant argued he was denied effective assistance of counsel because plea counsel failed to advise him duplicate jail credits could not be awarded on his consecutive state sentences. Defendant certified that if a plea counsel had advised him that he was not entitled to a duplicate award of 511 credits, he would not have accepted the plea offer from the state and would have insisted on going to trial. The trial judge determined, however, that the defendant received a host of benefits when he accepted the state's plea offer, and none of those benefits were affected by the number of jail credits awarded for his state sentences. Therefore, the judge concluded there was no reasonable likelihood that the defendant would have insisted on going to trial, even if his claim that he was misadvised as to the award of jail credits had merit. When a motion to withdraw a guilty plea is filed after sentencing, a trial court may only vacate a guilty plea to correct a manifest injustice. The judge properly denied defendant's motion after finding the rules were followed at the time of the defendant's plea hearing. Here the judge carefully considered the argument, and not one of the proposed errors supported withdrawal of the defendant's pleas under the manifest justice standard. Under these circumstances, and aware the judge chose to but was not obliged to revisit the defendant's aggregate sentence before directing defendant's state sentences to run concurrently, the Court of Appeal perceived no reason to disturb the judge's finding. In my opinion, it is annoying to me and should be annoying to both the trial and the appellate court when the state puts together a case to charge a person with fraud and then offers a plea to lesser charges only to have the defendant, like Mr. Amato, change his plea. If the judge agreed, he could have forced Amato to trial, and if convicted, a much greater prison term, or what the court did here was to deny the attempt to withdraw the appeal. People who commit insurance fraud and fraud of any kind and have no qualms, even after admitting to the crime, to try to get out of the jail sentence. It's ridiculous, and it is appropriate that Mr. Amato's attempt failed. Although maybe it would have been best for the state to try him and get him convicted on all of the counts they charged. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you can subscribe to the blog and you'll be given notice of all blog postings, usually 5, sometimes 6 a week. You will also be able to subscribe for free to the blog and to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com, and also subscribe to the videos. It helps. And if you're interested in further detail about insurance, insurance law, insurance claims, insurance fraud, you might consider subscribing to my Substack publication or my locals community for a very small fee. Thank you for your attention.